and local communities. And so far during this workshop, we've talked a lot about the relationship between academics, journalists, and experts, which have, especially in recent years, there have been a lot of focus on outreach. To what extent it's fair to say that these efforts have contributed to local ownership of these courts, or local legitimacy, if you want. And we will start with Alison Smith, who is a legal counsel and director of the International Criminal Justice Program with No Peace Without Justice from Brussels. So thanks very much. Yeah.
Thank you. I'm based in Brussels. I'm actually from Australia. If I speak too quickly or you don't understand anything, just give me a shout and I will try and correct myself. I wanted to thank particularly the OTJR for organising this meeting, which I found to be incredibly interesting and very useful. It's given me a lot of food for thought. And I particularly appreciate the interdisciplinary nature of the discussion, which I also find in the vibe somehow of Oxford as a city. So I wanted actually to start my presentation with a little interdisciplinary story, which may not seem relevant, but its relevance hopefully will become clear. So yesterday I was having breakfast at St. Hugh's College, and I was seated next to a medieval historian who was having a discussion with another historian about the Magna Carta. And they were talking about the parchment and the handwriting and all of this kind of thing. But what they said was the barons and the bishops all came to meet the king to have negotiations in French, to write the Magna Carta in Latin, that they then took with them, copied it down, took it back to where they lived. And then the interesting thing was over the next 100 years, they said you could see in some of the court cases that some provisions of the Magna Carta that gave rights to, let's say, the ordinary people were being used in court cases. So they were being used to help people win their rights. And I was thinking, well, the people probably didn't speak French, and I'm fairly certain they didn't speak Latin. So could this be one of the first examples of outreach, of the bishops and the barons taking the information back to the people, explaining it to them, engaging with them, and then seeing it actually making a difference in the lives of people? So I thought that might be an interesting research paper. But if we fast forward 800 years or so later, outreach was not a priority in the early years of the ICTY or the ICTR. It wasn't until the late 1990s that outreach really started to get some kind of recognition and some kind of prominence and importance. And this happened first, I think, at the ICTY in the late 90s, when they realized that for all the work that they were doing, they were actually having very little impact on the ground. There were very few people in the former Yugoslavia who knew what the ICTY was, who knew what it was doing, and so forth. And when we were doing investigations in Kosovo, we found we had to do outreach. So we had to explain what the ICTY was, manage people's expectations about what information they were giving us might be used for. But the ICTY started to pay attention to outreach in that time, and I think it's improved a lot since then, although we've had discussions about this, and there's others who are more expert than I am in the audience on that issue. Another thing that happened in 2000 was the negotiations began for the Special Court for Sierra Leone. It was negotiations between the government of Sierra Leone and the United Nations on the establishment of the court to address the atrocities since 1991 during the conflict in Sierra Leone. And what happened there was we started working with civil society at the end of 2000, beginning of 2001, to do outreach on the Special Court before the court was established. And that had two results, I think. One was that there was a well-informed, supportive and engaged group of civil society members who were ready to be a partner, let's say, for the court in doing outreach throughout Sierra Leone and then eventually also in Liberia. And the other thing was that it created a demand on the part of civil society that the Special Court would give importance to outreach, and that it would have an outreach unit, and that it would do outreach throughout the country. And I believe you're going to talk more about this, so I won't go into too much detail.
You know more than I do, probably.
But, one of the important points was it started to institutionalize this idea of outreach. But it still wasn't until 2005 that it became more institutionalized at the International Criminal Court when the Assembly of States Parties adopted the Omnibus Resolution, which is a resolution they adopt every year on strengthening the international criminal justice system, and they included a reference to outreach. So there were two important things about that. One was it gave policy importance to the issue, a direction from the Assembly of States Parties to the International Criminal Court that they had to do outreach and they had to do it well. And the other important thing is that it gave us a definition of outreach. So essentially the definition is that it's a two-way dialogue with victims and affected communities to promote understanding, to manage expectations, and to prevent misinformation or misconceptions. Or, as it turns out, to correct misinformation and misperceptions, given there have been issues, of course, with implementation of outreach. That's another issue. I think what's important to note is that one of the purposes is not to promote support. That's not the idea of outreach. The idea is to put people, victims and affected communities, in a position where they can make an informed decision about how they're going to view the court, about how they're going to view a transitional justice mechanism. Not everybody's going to support transitional justice, that's completely fine, but do so on the basis of correct information rather than on the basis of misinformation or conspiracy theories. Now, at best, I think outreach can lead to ownership, and in Sierra Leone, certainly civil society felt and continues to feel a very strong sense of ownership about the special court. It can also help with cooperation. I remember the delegate from Serbia in 2005 saying that he wished there'd been more outreach, because then it would have been easier for the Serbian government later on to be able to cooperate with the court and hand over indictees. But it's all about making the process work, and it's about delivering justice to people. Because you can do all the justice you like in The Hague, but if the people on the ground don't know about it, there's a question of whether it's really worth all of the effort. And in this respect, I wanted to, you mentioned about victims outreach and perpetrator outreach. I don't see that there's like two categories or two kinds of outreach. I think outreach is outreach. People tend to have the same information needs. They need to know what the court is. They need to know about fair trial rights. They need to know, what's going to happen. They need to understand the process as a whole. And perhaps an exception here is outreach on victims' participation, which maybe Gail will talk about, I'm sure. That's a different category, but in general, I think outreach is outreach. And people have different concerns and they have different fears, and you understand those through engaging in this process of dialogue, and you can address what people's concerns are. There are many ways that outreach can be done. I'm not going to go into any details about that, although I'm happy to speak more about that if people are interested. But there's, for example, town hall meetings, there's radio programs, there's leaflets, there's lectures, there's drama. We had a fun drama group going through all the markets in Freetown doing outreach on the special court. There's football. I mean, the ways that you can do outreach is limited only by the creativity of the outreach team, I would say. Now, in this respect, the media has two roles to play, as I see it, in outreach. And those journalists among us can, of course, correct me if I'm wrong. But the media is both a target group for outreach and they're a potential partner for outreach within the context of the role of the journalist, independence, and so on and so forth. They're an important target group primarily because they're part of the population. They have the same information needs as everybody else. But they're also an important target group because they provide information to the public, be it through radio, newspaper, television, or however else. So they need to know the basics about the court, and they need to know also things like who are the political backers of the court, who's funding the court, who appoints the principals of the court, the prosecutor, the registrar, the judges, where do the staff come from. And they need to know all of these things because these things make for very fun conspiracy theories if people don't know information about them. You all hear about how the US is not supporting the ICC and it's a tool of Europe and all of this kind of thing. So all of these sort of more institutional aspects really need to be known by the media. Then, if they want to, they can also be an important partner for the court. They can provide the court with space, for example, on radio, on television, and so forth. They can provide training, let's say, to other journalists, so take the information they've received from the court and make sure their colleagues know correct and timely information about the court. They can even possibly, engage with the court to say, well, this political development's coming up, you need to be aware, you need to be ready to react. The only final thing that I would say about that is, while the media can be an important partner, and indeed civil society and others can also be an important partner, it's absolutely critical that courts do outreach themselves, because there are some messages that can only come from the court. And this happened in Sierra Leone, for example. We could say until we were blue in the face, and did, that even though the court had jurisdiction over people aged 15 and above, we couldn't see how a child would fit into the category of those who bear the greatest responsibility for the crimes. And these were two elements of the special court statute. So we said this a lot, but people were still skeptical until the first prosecutor came on the radio and said, I am not going to prosecute children because I don't think they bear the greatest responsibility. And then people believed it. So there's an important role, I think, for the media to play, but it's the court itself that has to do its own outreach. And I think that's 15 minutes, so I will stop there and hand the floor back.
I will give now to Gerhard, please. And Gerhard Anders is lecturer in African Studies at the University of Edinburgh.
Thank you. I didn't know that 15 minutes were so short. The time flew. Was just settling in and hoping to hear more. But in some ways, my presentation, I think, will connect to some of the comments and remarks that Alison has made. So I think they fit nicely together. I've prepared a couple of slides, so just bear with me. Okay. Not much really, just a couple of pictures, of photographs from outreach events that were conducted by staff of the Special Court for Sierra Leone in parts of eastern and northern Sierra Leone. Now, in the past 2 days, this has been a terrific workshop and has been mentioned already, but I would like to add to that as well, that I think this meeting of practitioners, journalists, and academics of various stripe has been really terrific, fantastic, and I'm looking forward to further activities of this initiative. And you've been really addressing the right questions, I might say, and the question to whom do we reach out is one of those. That's absolutely spot on. To whom do we reach out, or to whom, not we, to whom does TJ reach out? And I might add why do they reach out, and how do they reach out, and as well as where, and I'll come to the location in a moment. And I would like to address these questions by drawing on my anthropological field research in Sierra Leone and Liberia a few years back. And it was part of a broader research project. I'm still kind of trying to write it up, but probably I'll give up now that the court has already seen the end of its existence. But I was trying to understand how criminal responsibility is being constructed through these trials, how legal technologies are being employed to ascribe individual responsibility. So that was actually what I was mainly interested in. But I was also interested in how the Special Court literally reached out to people. And it should be noted that, and Alison has mentioned this, the Special Court was really the first tribunal that took this, there were some beginnings from the ICTY, but it made it more of a sort of really explicit, we have an outreach department, and so it was a major nationwide initiative rolled out in Sierra Leone. And I think that's why maybe my fairly specific observations in Sierra Leone might have resonance with the theme of outreach in a more general sense, because this is in some way a laboratory, an experiment of outreach during the 2004, 2010. And I should also add that the special court, was explicitly set up in Sierra Leone to bring international criminal justice closer to the people in affected regions. And it's quite interesting then to see that the most important trial then was moved back to The Hague, actually. So yes, it was important to bring international criminal justice to Sierra Leone, but only up to a certain degree. Now, the employees of the Special Court for Sierra Leone conducted an impressive number of outreach events and radio programs in Sierra Leone, much less in Liberia. The Liberian outreach was always a bit of a stepchild of the outreach conducted by the Special Court for Sierra Leone. And in 2004, just to give you an example, that was the year the first two trials started in Freetown. The court's outreach officers conducted 780 events in towns and villages, the town hall events that Alison alluded to, 397 video screenings, and 654 radio programs and 165 school meetings. So that is quite impressive. It's for 1 year only. And the radio programs are particularly interesting, actually, because many of the radio stations, and this was a topic that was mentioned, I think, in an earlier panel, many of the people working in the radio stations were actually former rebels of the RUF, radio operators. So there was an interesting exercise of reintegration. So they played an important role in this outreach, actually. And yet, in spite of these impressive numbers, the outreach event, the outreach program was pretty much a shoestring operation, I would say, in the context of spending about $20 million a year on the tribunal. The budget for the outreach, I'm sure Alison knows probably much better now. I don't have the exact numbers, but it was never more than a few €100,000. So fairly small. So we have a shoestring operation within a shoestring court, actually, because the Special Court for Sierra Leone was seen as a shoestring operation as well. 20 million a year is dwarfed by 100 million a year or 120 million a year by the other tribunals. And let me explain what I mean by shoestring. Maybe some of you who have been to these outreach events would be familiar with that, but that is like the common picture that you would see, and Pierre refer to this. These courtrooms are set up for the media. You have cameras everywhere. So this is the usual view from the public gallery. And then look at the stark contrast of a fairly typical outreach event conducted in rural Sierra Leone, this particular one in a village close to Makeni in the north. And you can see this is a very low-key operation. It's being done in the village court, basically an open structure with a roof. You can see there a TV set. There's a generator somewhere connected to it, and a little speaker. So, this is a really small operation, not very impressive at all. I think there are other NGOs who have a much more impressive display than the Special Court for Sierra Leone. So in some ways, probably Mary's Meals or other NGOs are making much more of an impact in a way of a spectacle. So really a fairly modest operation. This is like where these were typically held. Drawing the villagers and everybody huddling around a little television set with a blaring speaker and a sort of rattling generator in the back. And it was actually very few people who conducted these outreach events. In Freetown, you had a small group of people, including a public affairs officer, a couple of technicians, and the management, at that time then headed by Binta Manzare, who later became the registrar of the Special Court. And in each of Sierra Leone's 12 districts, the court had posted 1 or 2 outreach officers. So these were local employees, Sierra Leoneans, usually from that part of the country, from that area, who were supposed to act, if you like, as foot soldiers of international criminal law, trying to convince people, trying to convey information in these events. And most of them had an NGO background. Many of them actually had been involved probably thanks to Alison in the civil society groups that were brought into the scene. So I remember a couple of people mentioning that they were actually working at that time, at the very early years, with the group for the special court. So I was shadowing these outreach officers during several months when they went about their incredibly difficult and challenging work, how they brought the court to the people, as they said, and how people reacted to the message of retributive justice that was being sent out by them. And in their day-to-day work, these officers conducted hundreds of these events. I mainly focused sort of in army barracks, police stations, schools, town halls, and so on and so on. I mainly focused on Makeni, Makburaka, Bo, Kenema, and Kailahun in the Far East. And these were very modest, as you can see, and mundane events, drawing, often a couple of dozen people, very intimate encounters in many ways. And I think that's made them so interesting if we're looking at these different views of justice or different demands for justice. And I have to distinguish them from much larger events that were carried out in the provincial centers with expatriate staff. So you had much larger events as well, but these were fewer, less regularly. And these were very impressive displays, so often expatriate staff being helicoptered in with a white UN helicopter, whole motorcade of SUVs coming in town, armed guards, the whole thing. But these were more intimidating in a way. So here, the audiences felt much more invited to actually say what they were thinking of the project of international criminal justice, and in particular about the Special Court for Sierra Leone. Now let me highlight 4 points that emerge from that research and that I think speak to some of the questions that we have addressed so far. Now, first of all, and this is crucial, the audiences the local outreach officers engaged with existed, and it was mentioned in the panel, in one of the panels yesterday on Somalia, in an information-rich environment. And I think that is important to really just remind us of that people usually have a whole range of different sources of information that they can draw on. And I have to say, I was fairly impressed by but maybe it was thanks to Alison's work in the early 2000s, but I was fairly impressed by the knowledge, the way that people articulated their comments, their questions, very well informed. They knew who the witnesses were. They knew who the protected witnesses were as well, often, some of them. So that was quite interesting. Of course, there's also conspiracy theories and all of that as well. But from a research point of view, the conspiracy theories actually often do hint at something which is often very true. Of course, the conspiracy theory is distorted. It is not exact a representation of the facts, but often people are onto something. They just have a different way of expressing it. Now, during these events, audiences, at least as far as I can see, and I could also see that because I was doing quite a fair bit of research in the rest of Sierra Leone as well, audiences were overwhelmingly critical. They did not really, any longer, this is now in 2009, this one, they did not any longer really buy into that retributive vision of justice. They were asking for distributive justice, if you like, for social justice, for development. Of course, the court officers would say, well, but we are a court, we do not deliver development, but people did have, again, a fair point. They said, why spend that money that we could use, and you're well familiar with that, why could we spend that money not on roads, on hospitals, and so on? And we said, no, well, the international community decided to give it to international criminal justice, so, that's what we give you, you better make the best of it. So we can really see a critique, articulate, passionate, and critical emerging in these events, and it is specifically about recognition of suffering and compensation for loss. It's about development. It's about social justice, as I've said. And now we should be very careful, of course, and just to say audiences were critical. These are just individual voices, and these events, even small ones like this, are pretty much choreographed. There's a choreography to it. You can see in the front row these elderly gentlemen, so these would be the village elders. Then the children kind of here then further in the back, the younger men, and then here, women. So, I mean, it's not like an audience is just one thing, of course. It's very abstract idea. So this is a crowd, and it's quite interesting to see that not everybody spoke, of course, and that there was a bit of a hierarchy who would speak when. So when I say people were highly critical, we have to unpack that, actually, because I was in this event. I don't know what people thought when they went home. I know, of course, based on my other research, that many people wanted to have some punishment for people who perpetrated crimes. Often they didn't think it was maybe the ones who were in the dock in Freetown, but maybe some guy in the next village who had led the RUF to the village and had directed the violence. So you would have that as well. But I think generally, by the late, but sort of 2009, people were pretty disenchanted. They were pretty disillusioned with the special court. I think I can say that quite safely. And they didn't think it did deliver what it promised to do. Now let me just add to that, and it has been mentioned as well, that the audiences didn't see the court as impartial or as objective. They saw the court as part of the political landscape of the country at that time. So I think, again, a point has been made already a couple of times, but it's important to do it. So because there, I think that's one of the challenges that outreach really faces, and that is that it is about information. But actually, I think, and there I would differ with Alison, it is about creating support for the International Criminal Court. So this information is not that technical thing that is being conveyed. People see it as a political message, and I think that's one of the main challenges, and that's why the employees of the Special Court were often struggling, because they couldn't say what was on their mind. They had the official script, and the official script was a fairly simplistic one. All right, I think I have a feeling I should move on to my next couple of points. I've scribbled something down here as well. I think an important point, though, is, so it's not about conveying information. It's about creating support for the court. That's what the court does. They have to legitimize what they do. And that's where another audience or another set of audiences comes into play, has already been alluded to as well. And that's audiences in the countries where the international criminal tribunals want to garner support. The capitals in Western Europe, North America mainly. So there are audiences there. And these audiences need to be convinced by the audiences, if you like, the public in Sierra Leone, that this is a worthwhile endeavor. And I'm not saying it is not, but I'm just saying how it operates. In these days, you need opinion polls. You have to show that the people in the affected regions want this type of justice. So you're using, in a way, these outreach events to legitimize what you are trying to do. And I think that's problematic as well, because it's instrumentalizing these events. So they do not turn into a two-way traffic, into a real public market or a public sphere. They are, instrumentalized in another legitimizing project with different audiences, more abstract audiences. What is the public in the West? What is the public in North America? Of course, is problematic. Now, this brings me to the next point. It is this legitimizing work that seems to be really at the core of what these tribunals do, and which often taints what they do. If you are in a domestic court, you do not have to work like part of your, half of your time trying to convince people that it's a good court. You can just assume that the court is there to stay. So that's one of the problems that the staff of the International Criminal Tribunals has been facing. They spent a lot of energy on trying to create support for what they were doing. That's why we have Naomi Campbell and Mia Farrow testifying in The Hague. Fantastic. Could be another paper. It's another presentation. It was a fantastic show, really. The only time that the special court had to wait was like, is Naomi Campbell is she in the house? And they said, she's in the house, but she's not yet in the courtroom, so you have to wait. So what you see is basically a PR strategy, and you need that these days, of course. I'm not saying PR strategies are per se bad, but in a way, sometimes I felt kind of the contrast. You have people here, you want to engage in a genuine, authentic discussion about international criminal justice, and then later you see, someone like Herman von Hebel quoting a survey of 10,000 people of which 91% said that the court is contributing to peace and reconciliation in Sierra Leone. That's a quote. And of course, I mean, who would disagree if you face a numerator, someone asks you, do you think the court for Sierra Leone is contributing to peace and reconciliation? You want to be polite, you don't know who this guy is, you will say yes. And so then you have 91%. Anyway, I don't want to really, maybe, there's more sophisticated analyses, but I think there is a problem there. So you have these opinion polls that are being used as a tool to convince audiences in the West, and I think that's not doing justice to these audiences. Okay. Now let me come to the third and penultimate point, and that is one point that was raised in the brief, is that I didn't have the feeling that these events, these outreach events, were actually a two-way traffic. They seemed very much a one-way traffic. They seemed very much a top-down situation. And that might be something, where also the court is at its limits in a way. I'll come to that when I come to speak a bit about practical recommendations. How am I doing on time? I can't read it actually.
2 minutes.
All right, no problem, sure. I thought you were saying like 45 seconds or something like that, then I would be worried, but 2 minutes. Okay, point being made, it's a very top-down operation. It's very much we provide information. We, the Special Court for Sierra Leone, provide information to you. We have a Q&A, so these events you would have a possibility for Q&A, but then it doesn't filter up. So basically the Special Court Outreach Officer gives a short presentation. They show some video footage of witnesses that are being examined in the courtroom, and then you have a quick Q&A of 15 minutes, and that's it. And people sort of wanted to use these Q&A sessions to really raise fundamental philosophical questions, if you like, about social justice. Well, not only philosophical, real problems for them. And then the court's officers, and I often felt they were really facing a very difficult task indeed, had to give them this very legalistic, technical thing. We have to, you have to prosecute the people who are accused of this. So they somehow they were at a disadvantage even. They couldn't engage these audiences kind of on an equal footing because they were bound by the simplistic narrative that they were supposed to present. All right. The top-down operation, I think, was characterized by 3 problems. 2 problems had to do with processes of translation, and I'll come to that then in the last 30 seconds. First of all, I think there was a problem with translation in the literal sense. Okay, so you have translation from English into Creole, the lingua franca in Sierra Leone, and then Timini, Mende, Limba, and other languages that are being spoken there, that are spoken in Sierra Leone. So you have a whole long chain of translation, and you have people who are simply not trained to translate this stuff. So you get very interesting results, and I can't claim to speak these local languages, but often listening to the final product, you you wonder sort of, what happened in between. It's like someone here starts saying something in the ear of the next person, and then it gets out there in the end, and, it's completely distorted. So that's one problem. The other problem, and it was mentioned in the very first panel on Colombia, is translation of these abstract legal categories into layperson's terms. That is a huge challenge, and I don't think that the Special Court did a very good job at doing this. They were just simply not equipped to do this. You start out as an outreach officer, you get a training in Freetown in the court's headquarters of about 4 weeks, and that's it. And and then you're just sent out there and you have to do it. So these are really major challenges. And the other one is the media technologies that are being employed. I was in awe of all the apps and the Twitters and everything. I mean, this is almost looks like a prehistoric operation with a TV set. Some posters here. This is a police station where they had an event. I'm sorry, bear with me here. Yeah, I mean, this looks like a very, this is a very low-fi. This is a very low-key operation. You have a speaker here, the TV set. So I think probably technological advance has made huge strides in the past couple of years. So I would be very interested to hear or discuss about possibilities for outreach employing these new media technologies, because these, quite frankly, didn't work. I mean, the speaker was blaring. You were sitting back there. You had no idea what was going on. Here on the screen, you see Charles Taylor. You have no idea. What is this going on about? What are they talking about? No idea. So these were this was the third challenge that they faced. Now, to wrap up, and that brings us to the concept of communities. It is as problematic as the concept of publics or audiences. Simply said, there are no communities, actually. It's a very convenient shorthand to talk about, reaching out to the local level, but there are no communities. There are no kind of unified agents or entities, communities. These are highly divided societies. That's what led to the war in the first place. And so there is no community to speak of, actually. You have differences, and I alluded to that, between village authorities, men, women, regional, ethnic, all of that. Perspective or view of the court was quite different in the north from the east. I can't go into that because Laila is looking at me very sternly, so you bear with me. But so just suffice it to say, and probably it's a moot point in a way because probably anyone here would subscribe to that. But it's you can't speak of these communities as a sort of entity. Often do we do it? Now bring me to the last thing: recommendations, kind of practical thoughts. Now, first of all, don't have poor translations for poor people. Invest in translations. Improve the quality of these translations. And it has been made also in relation to human rights language, that the process of translation is highly political. It creates often highly distorted results, and it often undermines the objectives of the human rights movement. So do spend a lot of energy on translations. Draw on expertise that is available, linguistic, anthropological. I'm an anthropologist myself, so I have to kind of offer the services of my profession, although they are not willingly rendered probably, but important point here. Number two, and I wanted to talk about that maybe then in the Q&A, make outreach more interactive. This was a very top-down operation. So the question is, are these new technologies that we have been discussing, could they play a role in outreach? Maybe they could improve, just scale up the whole thing, go from here to something which is much more contextual maybe, contextualizing. I was wondering, people in all these villages in Sierra Leone, they have had so many different experiences of the war. Why not use this as a fantastic resource in the outreach events and start asking people about what happened in this village, what were you doing? So instead, the outreach officers just gave this official narrative, but they could have made it more interactive. And that brings us to the last point, that is local ownership. Would that increase local ownership? I'm not sure. I'm not convinced, really. Why am I not convinced? I think that's where the limit, I just mentioned it very briefly, I think these are the limits of international criminal justice in a way. And maybe you don't want to have a criminal court that is locally owned. I would like to have a court that is, maybe at a distance when it renders justice. So I think this local ownership, and we might discuss this if you want, could be actually very problematic, actually undermining justice. I remember Phil gave a presentation a couple of weeks back saying that the very legitimization of international criminal justice is its distance to these crimes, and he problematized that. I agree with that, but even in a national context, you would like to have a judge that is not, locally owned, if you like. You want to have a judge that is independent, so there might be some tension there that we should need to address. And I think it's also, local ownership comes really here. Maybe the whole talk about participation, victims focus, as good as it sounds, it might be it is actually very difficult to implement it. Law in the end is violence. You punish someone, you lock someone away for many years. You send out a message that, if you act against the law, the law will strike down on you. So local ownership is actually complete in contradiction to the violence of the law. Law is violence, and it should be. It's punishing someone. So maybe proponents of international criminal justice should be less circumspect, play less to the court of public opinion, and just say, okay, we are bringing you the law, you better comply, or we'll crush you. Well, I don't know. It's just a thought. I think I have no more to say. Thank you very much. I'm looking forward to the next presentation.
And now we have Gaël Carayon, who is the ICC legal officer at Redress in London.
Thank you. All right. I'll try to stand up to the two presentations we've had before. Maybe to give you a little bit of background, I work for an NGO that does both advocacy in support of the ICC and its mandate and outreach on the ground, but focusing almost exclusively on victims' rights. So where we're talking about outreach earlier and who are we targeting our messages to, as far as we're concerned, even though we are aiming at having a broader message, one of our aim and goal is to explain to affected communities that the ICC recognizes some rights to victims, explain what these rights are, and make sure that if they want to, they're able to exercise them. That sounds very simple. It's actually not that simple because, and I think a lot, both Alison and Gerhard have mentioned it. One of the lessons I've definitely have learned through that work is we kind of need to leave our preconceptions home. We go in, we have these meetings, like Gerhard was saying, very local. We have our Q&As, we have selected our excerpts of videos to show, and we actually with questions that are sometimes very different from what we're ready to answer. And one of the limitations some of the courts face, which I think was mentioned just before, is they have their script and they're not always willing to move away from that script, which is where we sometimes may be able to help. One of my colleagues is in DRC this week doing outreach around the Lubanga judgments, the appeals, reparation, and all of that. Now, I'm here, she's in DRC, even though she may not be as familiar with all the ICC issues we're normally dealing, and sent me an email last night saying, I was ready to respond to all these questions, but they want to know who are the other perpetrators. And they also want to know, well, they say he's indigent. Who's made that decision? Questions that we're not ready to answer, or she was not ready to answer, and the court may not be ready to answer. So maybe just one lesson learned here is just to assume a bit less and also have that two-way discussion. It's not about us coming and informing only. It's also about hearing what the concerns are and taking them into account. Another challenge or lessons learned that was just mentioned is translation. When we talk about victims' rights, we're talking about something that's quite nitty-gritty legal work. What does participation mean? What does reparation mean? Oh, well, international has that whole broad concept of reparation. Well, in many languages, it's only translated as financial compensation. And if you're not aware of that, when you undertake your outreach, you're already from the start creating expectations and transforming the dialogue in a way. As far as the ICC's outreach is concerned, I think there's a few challenges that I wanted to touch upon. And the first one is confusion as to what outreach at ICC is. And I think Alison's mentioned it. It took a while for states parties to recognize that this was an important function of the court. I think in the early stages, people were not quite sure what it even meant. Is a tour of the ICC building outreach? Is that not? When clarity arose as to what it should or could include, funding became also an issue, and it still is the case. Organizations like myself or No Peace Without Justice have that fight every single year when the court's budget is discussed. How much should go into outreach? How important is it? Should we keep the office in that country? So last year, for example, because nothing had been happening in Uganda as far as the ICC proceedings were concerned, civil society on the ground, intermediaries, affected communities were informed that outreach was scaling down dramatically with possibly the closing of the office there. Now Ongwen shows up and all of a sudden it's, oh my, what are we going to do? Starting from scratch. But at the same time, there is a tension and a challenge there. How much money should you be spending for how long when nothing is happening? Is there a need for information when nothing is happening? Now, again, I don't think everyone would agree on that. We were at a meeting in The Hague a few weeks ago where people was like, well, stop disturbing victims all the time. Come and speak to them when you have something to tell them. And at the same time, I was in Uganda in March with groups saying, well, in the domestic proceedings in Uganda, in front of the International Crimes Division they're creating to try domestically some of these crimes, Thomas Coelho had been arrested, facing justice, but also with lots of delays because he was seeking amnesty. And the groups were saying, well, we don't have any information. Why is the delay? And the answer is like, well, nothing's really happening. We have nothing to tell you. We're just waiting for that judgment. People still wanted some information. So where do you draw that line? I don't have the answer, but I think these are some questions we need to consider. Top down, I think this is definitely one challenge we've seen with the ICC. I would say over time it has improved. There is more dialogue with the ground, with civil society as to how they can improve their messages. We're seeing a shift in the way the court itself is structured. The registry, which is the organ charged with delivering outreach and information, is undertaking at the moment a very big revision, restructuring of how they do their work. And one of the things they're recognizing is the need to be closer to the field, to empower those on the ground, to have more ownership about what messages they're distributing, how they're going to go about doing it, who are the best targets, because someone sitting in The Hague may not be the best person to make these decisions. So some of these challenges lie there. Who is the target audience is also a challenge, because even for us, we're focusing only on victims' rights. What does that mean? At the ICC, you can open a big investigation in a country, but then only 2 cases are brought. So are you talking to victims generally? Are you talking to the victims of that particular case? How do you deal with the fact that you may not know in the audience you've got who is who, and the different interests they may have? So that's another challenge in terms of having an outreach that's flexible enough and that you can adapt, sometimes directly when you're delivering them. I think, and I'll stay brief, but there are some challenges as well as to reaching out to particular groups of people. In the picture we were seeing earlier, it was quite striking. I think, you could see 4 women hidden in the back. Well, if you're trying to reach out to particular groups, such as women, such as children, then maybe a big town hall meeting is not the best way to do it. And maybe you need to have a separate meeting to enable them to raise their own views and their own concerns and ask their own questions, which may be very different from the ones from other groups. What else? Another challenge is what to say. So you've identified to whom, you've decided maybe you should do it or the court should do it, but what are you going to be saying? One of the aspects we've faced, and I think it's also part of the reason why you still need outreach directly done by the court institution, is we may not always have the same interests or the same views. I remember the first time I went to Eastern DRC, back in 2009, I think, meeting with victims of the Lubanga case or in that region, and the main question people had was reparation. And when we approached the court and said, okay, so what are you doing as far as information and outreach goes for reparation? The answer was, it's way too early to talk about it. We don't want to raise expectations. But where do you draw that line again? Because if you don't inform and if you don't build the capacity around these notions that are quite technical, when the time comes for reparation, you need to start from scratch. And then maybe other challenges are built in, which means you don't have the time or the resources to do that work properly, and people miss out. which I would say to me is one of the challenges they're facing now with the DRC cases that are at the reparation stage, is the judges have set up a deadline for a reparation plan to be submitted in 6 months. 6 months is a very, very short time if you have to inform, explain, and then give a chance for the communities to make an informed decision as to what it should look like, whether they want to engage, how they want to engage. On that particular point, and I think maybe to build on one of the questions for the panel, the role of the media, I think the media could be a useful partner for the ICC in helping them shape their messages to make them a bit more accessible. And we're guilty of it, I think, too, is we're so ingrained in our day-to-day work, focusing on the legal developments and the proceedings and the filings, that we tend to forget what we take for granted is not necessarily granted to someone who doesn't understand anything about law, has probably never seen a trial or met a lawyer, but has an interest in what's happening at this foreign court. I was quite shocked preparing for that mission in DRC, where I was selecting excerpts from the videos the court does, trying to say, okay, which bits may be interesting for local communities to look, which part of the trial. And one of the tools they're using, which in principle is a very good tool, is Q&A videos, where they have a court official answering questions that are based on questions they hear from the ground, and then you can just show their answer. But something quite striking is the legal jargon that's used even in these quite simple videos. I think 3 times in that video, which is about the reparation decision in Lubanga, first ever final decision on reparation in any case before the court. And the video kept saying, so the judges have said 6 months from the decision, we will have a plan. Why can't they just say 3rd of September? To me, it was just striking. It's a simple, tiny example, but it means if you don't look at when exactly the decision was issued or when the video was shot, nobody knows when that plan will be ready. When you watch the video, you're missing information. And I think that's where media experts could really enrich some of the tools the court is using. Who should do it? I think there's a role for everyone in a way. Our mandates complement each other. As I said, we may not have the same interests or the same views, but as I think Alison was said, it is incredibly important for the court itself to own its messages, and in doing so to coordinate between the various units. I think the registrar of the ICC has said it quite a few times. People don't necessarily make the difference between him or the prosecutor or somebody else in the court. I think the expression he keeps referring to is big man.
Mm-hmm. Yeah.
And it's true. When we go to the field, we sometimes have to explain quite a few times, we are not the ICC. And repeat it 5, 6, 10 times during the meeting. Like, we'll try to answer the questions and we'll exchange, and we'll bring your concerns to the court, because that's part of our mandate, but we're not the court. And at the end of the day, it's important to have some of these answers from those who make the decisions, and to not deflect some of these answers to other units. I can't answer because I don't deal with that aspect. Well, as far as the communities are concerned, this is one court. So why not have outreach that is a bit more coordinated, that has both someone from the prosecution's office that can explain why they didn't select other cases, why the charges are so narrow, someone from the Trust Fund for Victims, that beautiful body that's supposed to provide assistance to victims before there is reparation, or also to implement reparation, to explain why are they in one country or why not, how do they select projects that they support. I think there is a bit of progress. I don't want to paint too bleak a picture, but there's still a lot to do. Finally, and I've already touched upon it a little, but which format to use your outreach. I agree. Watching a video on a tiny TV, and I've done it on my even smaller laptop, is not great. But at the same time, I was quite surprised by how powerful it was as a tool with some of the groups we've met. And here, I mean, I'll agree with what Phil Clark was saying this morning. It's only anecdotal. I don't pretend to speak on behalf of all the groups everywhere, but some of the groups we've worked with, video is very important. When you bring that back to those paying for these videos, the state parties, we've had to fight to keep them. Because in their view, it was a huge expense to record proceedings and then edit and then put it together, and they didn't really see a use. Only by listening from the ground, from those actually doing the outreach, did they realize that. Then I know we're running out of time, so I'll just touch maybe a bit about another, like in terms of the way forward, and I've mentioned the fact that the courts registry is going through a restructuring and a process. I think that there is a bit of hope. There's a lot of lessons learned from what happened in Sierra Leone, from some other experiences. The ICC is learning, but I think there's also a lot of lessons learned that can be drawn at the domestic level in domestic transitional justice efforts. And for that, I'd say, well, if we just look at what's happening in Uganda, I won't pretend I know how good their outreach is. I wasn't there, but one of the things the local International Crimes Division is hoping and trying to do is to do outreach. I think that there's a meeting probably a week or two ago where they went and they met with communities in the north to explain their mandate. So there's clearly an appetite, and I would think some lessons to be learned that can be used to make these processes also a bit more effective. And I'll stop there.
Great, thank you so much. Do we have questions?